Our next topic is essential elements of a contract. However, before taking up this topic, I like to tell you that we'll be taking each of the elements in detail in our coming segments. So I would just brush upon all the elements in short. And for that, I'll bring up this slide before you, which we have already done when we were understanding the nature of contract. In that, we have already gone through the essential elements of a contract, which were intention to create legal relationship, lawful consideration and lawful object, capacity to contract, free consent, agreement not declared void or illegal, certainty of meaning, possibility of performance of an agreement, and necessary legal formalities. Since we'll be doing this in detail, I'll just brush upon all these points. Intention to create legal relation. Now, whenever you make any contracts, you always tend to bind the other person legally. That means if the other person does not perform his promise, you'll always want to get the promise enforced in the court of law. You'll always try to take him to the court. And when you intend this, you can say that you are creating a legal relationship. And in all the contracts which are of business nature, which have a nature of business, the parties always tend to create legal relationships. However, in contracts which are of social nature, which are of domestic nature, which are of religious nature, no legal relation is intended there. Our next point is lawful consideration and lawful object. The consideration should be lawful. The word lawful implies as per the law, not against the law. So the consideration, that is, when you do a promise, what you get in return is the consideration. So whatever you are getting has to be lawful. It should not be against law. Like if you are doing something for someone, you should not get something like drugs in return, something like guns, or something like smuggled gold in return. If you get these things, these will be unlawful. So the consideration for a valid contract should be lawful. Not only the consideration, but the object should also be lawful. That means the basic purpose or the motive of the contract should be as per law. It should not be against law. A contract to murder someone, a contract to rape someone, all these contracts which are against law will be unlawful. So there should not be a contract wherein you are trying to murder someone. There should not be a contract where you take money to rape someone. These contracts would be unlawful. Your contract should be lawful, wherein you are purchasing goods, you are purchasing some property, you are selling a vehicle. These contracts, which are of normal business nature, would be considered as having lawful object. The next is free consent. Free consent means the consent which is given freely, that is free of coercion, that means physical pressure, free of undue influence, which means mental pressure, free of fraud, which means cheating. It should be free of any cheating, free of misrepresentation, which means an innocent cheating, an innocent fraud, wherein you do not actually intend to defraud the counterparty, but in ignorance you tend to defraud him. And finally, it should be free of mistake. The contract should not have been made on account of mistake. So when all these things are absent, you can say that the consent is free. But if any of these things is present, the consent won't be free. Next is agreement not declared as void or illegal. Law has declared some agreements to be void and illegal, like you cannot trade with your enemy. For example, Pakistan is our enemy. So you cannot continue trading with Pakistan if Pakistan is at war with us. Same is the case, take the case of China. If China is at war with us, you cannot trade with any company, any person in China, because that would be void, because the law has declared it as void. Likewise, you cannot enter into marriage brokerage contract. I mean, you cannot have commission or brokerage if you set up a marriage of two persons, and if you do that, that contract would be void or illegal. So in this way, law has listed some contracts which are void and illegal. You cannot have those contracts. Next is certainty of meaning. In contracts, the meaning should be certain, it should be definite, it should be unambiguous, it should not be vague or loosely meant. Everything, the object and the terms and conditions should be perfectly, precisely defined. Next is possibility of performance. You should make agreements in contract of those acts which are humanly possible to perform. All such contracts which are humanly impossible to perform will never form valid contract. A contract to bring moon on earth would be humanly impossible. So such a contract would be void. A contract to write 100 pages in 1 minute, again this would be humanly impossible. So such a contract would be void. So all such contracts which are humanly impossible are void. So for forming a valid contract, you have to form contracts of the acts which can be performed by humans, which are possible to perform. Next is necessary legal formalities. Now this is not a required essential in all the contracts, because this is required only in some contracts. Contracts like sale and purchase of properties, they have to be in writing, they have to be signed, they have to be stamped, they have to be registered. So these legal formalities need to be followed. But for making normal business contracts, these legal formalities can be ignored. There's one more essential, which is capacity to contract. Capacity to contract means you should have the capacity, the ability to enter into contracts. There are three things which will stop you from entering into contracts. First is your age. If you are a minor, you do not have the capacity to enter into a contract. Second is unsound mind. If your mind is unsound, you cannot enter into contracts. And third is, if you are disqualified, again you cannot be entered into contract. You cannot enter into contracts. Now, law expressly disqualifies some persons like criminals, insolvents, foreign ambassadors. These people cannot enter into contracts. They are disqualified from entering into contracts. So they do not have the capacity. So three things will stop you from entering into contracts. First is age, minors cannot enter. Second is unsound mind. If you are lunatic, if you are an idiot, you cannot enter into contracts. And third, if you are a criminal, if you are insolvent, if you are a foreign embassy, you cannot enter into contracts. So three things stop you from entering into contracts. We'll discuss all these things in detail in our coming segments. So this brings us to the end of the first unit, which was on the nature of contract.